first, I want to thank everybody at Glen Oaks because without you guys, this would not be happening. So thank you so much for giving me the opportunity to share information so all of you can understand these concepts and help your clients. The goal that we have is to prevent as many people as possible from going through the probate court system. So the more education we can provide, the better. So that's what this is all about for me. So my goal today is just to teach you so you can teach others and become a resource for you if you have questions or things come up, that we can always talk through issues and come up with some sort of plan to help. So I'm gonna start if it works. Oh, here we go. Okay. So estate planning 101. Now, many of you may already know about estate planning. I'll go through this pretty quickly. We'll save questions for the end, or you can type them in and Lauren will somehow filter them. I know it's a lot to go through some of the chats. So the reality of estate planning is that we have to plan for both incapacity and death. We cannot just plan for death. And so many estate plans are really anemic or missing documents on the incapacity planning. So let's talk about the incapacity planning first. The Advanced Healthcare Directive is the document that you need if you are over 18 years old and you want to avoid court if you become incapacitated. So this is for everyone over 18. This is not just for old people. If you have an 18-year-old kid, the health system does not allow you to make medical decisions without a directive. You cannot do it for a spouse. You cannot do it for an aging parent. Everybody over 18 needs an advanced healthcare directive. If you want to choose who cares for you, you've got to name this in the advance directive. If you want to make sure your wishes are honored, you have to pick the right person, and you have to make sure that you write down what your wishes are. Now, a lot of these fill in the blank forms are pretty bare bones, so they don't give a lot of these details. But I think the advance directive is the most important document out there because it means I'm alive, but I'm incapacitated. So I want to make sure that someone can honor my wishes. And so they have to know what it is. People don't usually talk about these issues. And I think the thing I hear the most from people is they want to relieve the burden on their loved ones from having to figure so much out. So it's important to write these things down. So the HIPAA waiver is the HIPAA law is the Privacy Act between the doctor and the patient. It became law in 2004. So all older advanced directives before 2004 will for sure not have a HIPAA waiver. We still see them now where, I don't know, it's like 2016, 2012, and they don't have HIPAA waivers. So if you have an advanced directive already, be sure to make sure that you have a HIPAA waiver. This will allow the medical community to talk to your agent and tell them what's going on about your care if you need to help out. The POST is the physician's orders for life-sustaining treatment. It replaced the DNR, the do not resuscitate. So if you have family members, friends, clients, whomever, who are toward the end of their life and they do not want to be resuscitated, they have to fill this out and they have to get the doctor to sign it. And it should be posted in a place that first responders will see. So that's the POST. Now let's move on to the durable power of attorney. So the advance directive and power of attorney are both for incapacity, and you need them once you turn 18. So the same thing, if you are 18 years old and you want to avoid court, if you become incapacitated, you want to fill out a durable power of attorney for finance. This is the person who handles the day-to-day legal and financial affairs. If you also have a trust, this person is doing everything outside the trust. If you don't have a trust, this person is handling everything. And again, if you want to relieve the burden on your loved ones. So those are the two main documents, plus the HIPAA waiver that we use for incapacity planning. And then on the death side, we talk about a trust or a will. So let's talk about the trust for a minute. This is if you want to avoid court and you want to determine who's going to get what when and how. If you have kids or assets like a house, this is when we start really thinking about a trust. And if you want to have some special rules for certain beneficiaries, they're not all the same necessarily, then we can do that. And so we can control from the grave in a trust. We can sprinkle assets over time for kids. We can have conditions for them to inherit. They have to be, productive. They can't be trust fund babies. They can't, be drug addicts. They can't be in jail. Whatever the rules are that you want to set up, this is what we do in a trust. The alternative is a will. Now, a will says who gets your stuff when you die, just like a trust, but all wills go through probate. So let me say that again. All wills go through probate if you have over $166,250. So most people think, oh, I have a will, I'm fine. That's not true. If you have less than $166,250, then you will not go through probate. But we want to make sure that if you have over that, and most people, if they have real estate, they're going to be over that, then we want to do a trust, not a will. So a basic will, if you don't have a trust, it may or may not trigger probate, depending upon the asset value. And it's going to give it to your kids at the end of the probate. So if your kids are too young, and they shouldn't be able to receive that much money. If they're a minor, they can't, and the court has to name a custodian over the money until they're 18. If they're over 18 but under 30, arguably they shouldn't be managing this money because they might not spend it wisely. But in a will, you can't control it. It's just they're going to get it. And so no controlling from the grave. The pour over will goes with a trust. So it's the trust-based planning, and the pour over will catch up to $166,250 outside of the trust. Now, I was just emailing this morning a financial advisor at a very well-known institution with very high net worth clients, my client being one of them. And he was telling his clients, including mine, oh, just keep these assets outside of the trust. The pour over will handle it. And it was like over $800,000 just for her. And he's like, we tell all our clients this. I'm like, are you kidding me? This is coming from an advisor. So it's really, really important for you, for your friends, for your family, for everybody. Be sure you understand that pour over will has a safety net, but it breaks at $166,250. All right, so that's kind of estate planning 101. And I will, for sure answer questions at the end of this. If for some reason we run out of time, I'm always happy to talk on the phone afterwards. So the default planning in California, if I had everybody raise their hand and say, how many people have a comprehensive up-to-date estate plan? Most people do not have one. So that's why I just call it the default California plan. And it is court-based. So if you are over 18, you lose capacity, and you do not have an advance directive or power of attorney, you're headed to conservatorship. This is where the judge is going to decide. There are two types of conservatorship, one over the person and one over the money. So the judge will decide who takes care of you. It may not be the person you want it to be. The person you may want it to be may not have the money to petition for conservatorship. I just got an email this morning from a woman I've talked to 2 times before who said that her sisters are doing things they shouldn't be doing with a parent, and she really wants to petition for conservatorship, but she can't afford it, and to litigate might be $50,000 to $100,000. So if you have your advance directive and power of attorney and you've named the right people, super important that you're naming the right people, then hopefully that is taken care of. Conservatorship is really expensive. So it's about $10,000 to start and $5,000 every year thereafter for the rest of the person's life. This could be your spouse. It's not like this is some distant relative you're trying to care for. The judge can also strip you of your rights. You can't vote, you can't drive, You can't have a professional license. It's up to the discretion of the judge. So Stacy and Vinny are dear friends of mine and clients. And normally I can't ever disclose who my clients are, but she wants to teach as many people how to avoid this as possible. Vinny had an accident many, many years ago, probably 25 years ago now. He had a brain injury. He was a director of photography and fell off the rig as they were filming, was in a coma. Long story short, he now has the mental capacity of a 6-year-old. She's been taking care of him for 25 years. They were starting to do their estate planning documents. It was all on the computer. Nothing was executed. It doesn't matter. She had to get a conservatorship over her husband, and she has to tell the court and prove to the court for every penny she spends on him and get the approval of the court. So when his mom died several years ago, she called me and said, well, I want to give money for the funeral. And I was like, how much money do you normally give? And she said, I don't know, not that much. They didn't need it. And I said, well, we can go to court and ask for permission. And she was like, that's going to cost me more, even though we give her a discount because she's a friend, right? That's going to cost me more than how much I was going to give them in the first place. So conservatorship is awful, and it is almost entirely avoidable if you do your homework. Now with COVID and everything going on, it is more important than ever for every single person over 18 to get their advanced directive and power of attorney done. So we avoid conservatorship. Okay, probate. Probate is the other part of what we deal with, and this is after you're gone. So if you had over 166,250, this year they changed it to that. It was 150,000 for many years in the past. So it was so much easier to say. So if it's over that amount and you're dead, you're going to go to probate. And the asterisk is there at the bottom. It says it excludes if you have joint ownership over the asset or if you have a beneficiary designation. So we're only counting what does not have a Benny designation or joint ownership in that 166,000, and only assets that are traceable, right? So if you've got some fabulous diamond ring and it's worth a lot, and you add up all your jewelry and all of your collections and, you know, whatever, if it's over 166, I don't care, nobody knows about it. But if it's got a paper trail to it, then we care about it. Okay, so all wills go through probate with those parameters in mind. Probate is a public process. People come out of the woodwork. Families, creditors, super expensive. It's roughly 3 to 4% of the fair market value of the estate. You do not get to subtract a mortgage. And the idea is who will be the executor. So you think, oh, I've taken care of it. I've written who the executor is in the will. It's your favorite kid or best friend or whatever, but they don't have good credit. And they don't have great income, so they don't qualify for the bond. And that means that they're not going to be the executor and somebody else is. So it's not just that you name the right person you want in there, they have to qualify for that bond. And then the assets are frozen until you have letters from the court. And normally our probate process takes about a year from beginning to end with the court closures. Clearly it's more than that. If it's a spousal situation, your spouse is probably relying on the assets not to be frozen. So if you have not done this well and you are the sole owner of the asset, bank account, investment account, whatever it is, and you don't have them as a beneficiary or a joint owner, those assets are frozen. It doesn't matter what your relationship is. So it's devastating when people come to us and this, you know, foreclosures start, the process can start happening. It's very scary. And you're supposed to be grieving during this time. This is not supposed to be the time you're dealing with legal, for those of you who don't know me, I swear all the time, legal bullshit, right? It's supposed to be seamless on the legal side so that you can be emotional and human on the other side. This is a simple chart, a fee structure for probate. So let's just say somebody passes away and they have $800,000, including their house. And even if they have a $700,000 mortgage, the minimum probate fees are $38,000. Half of that goes to the attorney, half of that goes to the executor. So I joke and say, like, don't waste your money on attorneys. I mean, I love my daughter and I need to, you know, put her through college, but you should not be paying me all these fees when you could have had a trust and saved so much money. And then of course, we have to add a little humor. So I can't see people's faces. I hate that, but people fight over everything. And my favorite part of this that I didn't see when I first saw this was all the weapons behind their backs as they were promising not to fight over the money. Okay, moving along. Successful planning. So I get this question from some people, like, what does it mean to have a successful plan? I guess our definition here at Goldfarb Blue is really exceptional, even though I think it should be very standard. We want to honor our client. We want to make sure the wishes of our clients get honored, their estates avoid court, and their families maintain harmony. Seems pretty simple. And yet, of the plans that come to us, 95% of them have a fatal flaw in one of those areas, and usually the client has no idea. So just to give you an idea, our malpractice insurance as estate planning attorneys is higher than any other type of attorney because people don't realize that we screwed up for like 20 or 30 years later. So, and clients, you know, I kind of chuckle inside. People say, oh, the attorney was fabulous and so smart, and it was a great experience, and I know they just did a great job. And then we look at the documents and there's just one fatal flaw after another, and they just had no idea. I mean, how would they know? So on the document side where the wishes won't get honored, it means the documents might be outdated. So people's wishes change and the people in place change. Maybe they selected the wrong people. Maybe they want their 3 kids to be, you know, durable power of attorney agents together or co-trustees together. Some banks won't even allow that many people to be powers of attorney. And having several people, your children, be co-trustees is pretty much a recipe for family disharmony. Sometimes we see really poorly drafted documents that are unclear. So, so we don't know exactly what the wishes, what the intent was. The part where it says won't avoid court, we see it sometimes missing documents. When I first got my estate plan done from a really reputable estate planning attorney, we bought a house, we wanted to put it in a trust, and all he did was create a trust for us. No pour over will, no advance directive, no power of attorney. And this is a guy who had been practicing for 30 years. No discussion about it, no education, no nothing, just, oh, here's your trust, that's what you asked for. Unconscionable to me. So we see missing documents a lot, or you've selected the wrong people or poorly drafted and it leads to litigation. The trust not being funded is a big deal. So I would say almost 100% of the time, the trust is not funded properly. So remember when we talked about the 166,000, if we look at all the assets together and we see what's in the trust and what isn't in the trust, almost every person who comes to us with an estate plan, they have more than that 166,000 outside of the trust. And destroying family harmony, I guess it's mostly selecting the wrong people and acting without good counsel. But what we see a lot of is there just isn't the outside of the box solutions to family drama. And if, you know, I always ask people, like, how many people have family drama in their hands? And like, some people raise 1 hand, some people raise 2 hands, right? I mean, it's normal. And as a matter of fact, when we have clients who come to us and I ask about this and they say, nope, everybody gets along perfectly, I'm always like, are you sure? Because I think there must be some drama under there somewhere. Sometimes you have to do outside of the box things to try to prevent more of it from happening. Okay, so elder law. I'm not going to talk too much about elder law. We only practice estate planning and elder law, but I recently, before all this COVID stuff happened, was sitting at the park with my daughter, and she started playing with this other little girl, and then the mom and I started talking, as commonly used to happen when we go to parks. And she was just telling me about her landlord, and he didn't have anybody. And so there were just realtor after realtor after realtor trying to sell this house for him. Now, I don't know that he needed to sell the house, but he had questionable capacity maybe. And I think they were just like trying to make this deal. And, you know, there's tons of unethical lawyers out there. So I'm sure it's in every industry. So I just want to talk briefly about it. So elder law is triggered for me when the role reversal happens between parents and kids, or you don't have any kids, but you start needing help. And so this can cause tons of stress on relationships and finances. And elder law lawyers have a whole bunch of tools in our toolbox to help provide resources and give guidance. I mean, in every single intake that I do for a new elder law situation, after that 20-minute phone call or so, almost universally, the person, I can hear them breathing differently, and they just tell me, oh my God, there's a plan now. I feel like I can handle this now. So it's a mixture of therapy and law. So, you know, all the issues that you think when I only have one kid. Well, I have my stepdaughter, but she's 35, and my daughter who's 5. So they get along perfectly and love each other dearly. But, you know, normal age gap siblings who grow up together, there's shit from your childhood. As an only child, I don't have that to fight with, but there's stuff, and it just surfaces when elder law is triggered, when capacity issues start being prevalent, and certainly when someone dies. So for sure on the elder law side, I mean, we use our knowledge of the law, obviously, but it's mostly therapy and helping people navigate through it. So there's the senior real estate specialization, and this is for buyers. So many of you may know about it already. It's a certification you can get to help buyers and sellers. And so I looked it up last night. It said 50. And as you know, I'm a swearer. And if Marcine is watching, she knows. So what the fuck, 50? I'm 50. This is not okay. Elder law to me is like 80s and 90s. Okay, anyway, so there's a lot to learn. I've heard from different real estate agents who have this certification that it is, there's a lot of great information, and obviously we have lots of seniors who are buying and selling real estate. So my biggest thing in elder law is you gotta have your A-team. You gotta have all the people in place, not when you turn 50, but when you're in your 80s and 90s, right, or you're caring for people, have these people in place so that when things happen, you know, it's the elder law attorney, it's somebody to help with some financial planning maybe, it's having a placement person if someone might need to go into a community, or having the resources to have some caregiving at home. And the laws, by the way, if you know anyone, the laws for caregivers at home are super important to follow. The penalties are astronomical for paying under the table. So if anybody has those situations that come up, I don't have time to go into it now, but it's really important to do it by the books. All right, so serving your clients. I was kind of thinking, like, how do you stand out in your industry? And so obviously all of you are great at what you do. I think that a service that you can provide, because remember, to avoid court and all the planning we do, people just don't know about it. And so you guys who are helping people with their home purchases, and even, you know, title and escrow and everything, the more times people hear this, hey, you guys really need a trust. Do you have a trust? Let's put it in the name of the trust, right? The more they hear about it over and over and over again, the more likely they are to do it. So explain to new and expert buyers the importance of having an up-to-date plan. These plans are not meant to be 20 years old. So I think that if you are comfortable talking with them and saying, you know, you said you had a trust, but how old is it? Because if you did your estate plan a while ago, the laws have changed, and maybe your wishes have changed. And so you want to make sure that you update it. And if there's any way that you can help fund their trust, so talk to title, work it out with escrow. If they have a trust, make sure that it's recorded in the trust. Remind them that if they refinance and for some reason the financial institution asks them to take it out of the trust, that doesn't happen as much as it used to, but that it has to go back in, because we see that sometimes too. And then maybe, you know, you have like a congratulatory kind of package, or you have newsletters or marketing emails. Include some estate planning facts in there so that the more people who learn about this, the better. And if you need like little tidbits or things, you know, I could send you some things and you could include those. And I think for everybody, just being that resource hub is important. And I know a lot of you are already. So I know about this transfer on death deed, and I remember talking to Marcine a while ago about it. It came out in 2016, and she just said, like, it's terrible, don't use it. But I didn't really learn about why. And so when I was preparing this presentation, I learned about why. So it's really a terrible idea. All right, so, and this is in lieu of a trust. So it's new to California in 2016. Over half the states have it. You can only use it for single family homes, condos, farms of less than 40 acres, and residential units with no more than 4 units. So that's fine. Has to be notarized and recorded at least within 60 days of being signed and before the owner dies. That's fine. You can't have contingent beneficiaries. Okay, well, that's not as good as a trust, but that part's okay too. So it's void at the owner's death if it was like a co-ownership. So husband and wife have it, and then husband wants to give it to daughter, right? You can't do that because it should go to the other spouse. So that made sense to me. So then it said that the transfer on death recording voids title insurance, and I remember this is what Marcine told me. So that's not good. And then many will not issue new title insurance after the owner dies, and there's for 3 years. So for those people who are planning on selling it after the owner dies, they're not going to get title insurance. And you all know better than I do, what buyer is going to buy a piece of property without title insurance? So I didn't realize this. If the owner becomes incapacitated, you can't sell it or get a reverse mortgage to pay for long-term care costs. So this could be devastating. There are so many people who are relying on the value of their house to help take care of them when they're older, because long-term care is so expensive. We have 2 clients right now who have in-home care 24 hours a day. If you do it by the books, the way I was suggesting, it's $230,000 a year for a live-in caregiver. So that money runs out fast, and you might need to access some equity in your house. And then this was really bad. The transfer on death beneficiary will be personally liable for the owner's debts for up to 3 years. That sucks. Which also leads to the house is recoverable for Medi-Cal purposes. So one of the advantages of having your house in a trust is if you're on Medi-Cal, once you die, you can't recover against it. That doesn't work with this kind of transfer. And so then these deeds are set in California to expire at the end of this year if our legislature doesn't extend it. I don't know if they're planning on doing it or not. All right, so elder abuse, we see a lot of it. There's many different types. The primary ones are physical, financial, and emotional, but there's like 9 different kinds of elder abuse. And so if you suspect that a client doesn't have mental capacity, I think it's really important to figure out who is the proper person for you to be dealing with. And so it probably happens less on the buyer's side, but more often on the seller's side. So if you know, little old lady or little old man has a house and you can't really deal with them, but their kid is the one who's the one you've been dealing with a lot, you better make sure that that is the durable power of attorney next in line, or the trustee next in line, so that you're dealing with the right person. Because I know all of you you know, these are based on commissions. And so you could spend all this time and then it could blow up because you're dealing with the wrong person. So, and if you suspect that there's any shenanigans going on by a family member or a friend or whoever is the person you're dealing with, trust your gut. We are sort of taught in our culture not to trust our gut, but in my area of law, you have to trust your gut. So I'm happy to talk through issues. If you get into one of these tricky situations and you just want to pick up the phone and you know, schedule time to talk so that we can walk through some things, I'm always happy to do that. And if you believe that a fellow agent, like these agents where I described this woman in the park's landlord, are acting inappropriately, report them. You know, within real estate offices, there's not like normal supervisors like there are in, you know, regular businesses, but at some level there is someone to go to. If you feel like you have to call Adult Protective Services, you can do that. They're not super helpful because their caseloads are high. And if you think it's criminal, then call the police. There are elder abuse kind of specialist detectives in some police departments, not in all. They have the physical side and the financial side, so probably you'd be dealing with the financial side. I just feel like it's our duty to protect our elders. I mean, we're pretty shitty to our old people here compared to other countries, and we need to do a better job. We have so much to learn from them. I'm gonna get like all emotional. It's everybody's job to look out for them. Okay. So in summary, and then we can talk about any questions. We want to avoid conservatorship by having the advance directive and the power of attorney. It's important to keep the documents in a place that other people know where they are. So I'm going to just share a quick story. And I emailed him this morning for an update, but I haven't heard back. So on Friday, I spoke with someone whose dad was dying in the hospital, and he and his family members wanted to pull the plug because he had very little brain activity, and the doctors all said he was brain dead at an extraordinarily reputable hospital. 5 doctors confirmed this, and his wife said no, he's going to wake up. They didn't know where the advance directive was or if there was an advance directive, so he's like frantically, I mean, as calm as he could be, but calling to try to figure out what to do. Maybe it was in the safe deposit box. Do you think the bank cares? No. So they said, oh, get a court order so that you can access the safe deposit box. They didn't even know if there was one in there. So for your advance directive, keep it in a place that your next in line knows where it is. Give them a copy if you want. We like to make all of our advance directives and powers of attorney immediately effective. So some people don't want to give out the documents early. I think with power of attorney, I think with the advance directive, give it to them so they have it handy. With the power of attorney, what I tell clients is just tell them to contact us if something happens, so that we can be that liaison. All right, and then avoiding probate is having a complete funded trust that's reviewed and updated as necessary. Use elder law attorneys as clients age because it will be a much better service for them. And not all trust administrations are the same. So as Taryn, my daughter, says, easy peasy lemon squeezy. So if you have a great trustee in line for trust administration, we figure out assets, debts, and taxes, deal with the distribution plan, there's family harmony. If you have a bad trustee, someone who's just terrible or they're doing shady stuff, then we have to go to court to try to remove them. If the assets aren't in the trust, we have to do a Hegstead petition. Then we're dealing with debts, taxes, and distributions and the family feud. So it's important to have that done. The elder issues, listen to the right people, trust your gut, report and protect, and be that resource hub. Get your own aid team ready so that you can refer that to clients. I have a checklist here, and and it's too hard to see it here, but I'm happy to email it to anyone, and you can forward it to whomever you want. And it's just things to really pay attention to within your estate plan. So that is helpful for some people. And then this is just our contact info. So if you have any questions, you can always reach out to us. That's it.
Okay, we have some questions, and before we get to the questions, I'm going to just remind everybody to put your email in the chat so we can email you the form that Rebecca just showed, and also the presentation and the recorded link so you can go back to this entire presentation and share with clients if needed, or just revisit it if you have any questions. And we'll copy Rebecca and have her info so you can reach out to her directly as well if you need direct. Okay, we're going to start at the top. We had a question from Mary Ann. She wants to know, can the trust, executor, and power of attorney be the same?
Yes, so just for the terminology, it's an executor of the will and a trustee of the trust. Your power of attorney can legally be the same as your trustee, but imagine that you're incapacitated. There's no checks and balances there, right? So your durable power of attorney is paying all the bills and handling the legal and financial affairs, and the trustee is managing the money. So when you're the same, there's no checks and balances, but that is often fine. And so that can work. Once you pass away, the advance directive and power of attorney pass away with you. So then all that's left is the trustee. So if you never become incapacitated, you would never have used your power of attorney, then you would just be using what your trust says.
Okay, perfect. And then next from Kirk, we have, is the POLST form a California thing or national in terms of override on the DNR?
So it started in Washington and Oregon about a decade ago, and it has migrated across the country. Many states, I don't think all of them have it, but almost all of them have it, but they don't all call it a POLST. Some call it a MOLST, medical orders for life-sustaining treatment. Some are on green paper, some are on blue. The majority of them are on pink. And it is the new DNR. And this is why the DNR didn't work, because it was a couple pieces of paper stapled together, usually kept in a safe deposit box or somewhere on a bookshelf or filing cabinet. When you have coded, when you have died, you have no pulse, no heartbeat, who has time to go find this DNR? So they just weren't honored. And so they came up, very smart people came up with the POLST. It's printed on this hot pink piece of paper, so it's posted. So first responders are trained to look for it, and then it follows you from the home to the hospital to the rehab and home again. So everybody is really well aware of what your wishes are.
Okay, and then Mary Ann has a question. If there's a trust, AD, power of attorney in place, is it a good idea to have an independent third party or an attorney review that?
Yes, because so many of them are flawed. So I would recommend, you have to be comfortable. So we review estate plans all the time that are created by other people to, at minimum, just tell people, here's what it says, and here are the red flags that we see, and then what do you want to do? In the last, I think, 3 years, we've had one person who said, no, I'm good with the way it is. And every other person is like, what are you, that's what it says? Why didn't they tell me? I didn't know. And it's this whole long thing. So reviewing it is always a good idea.
Okay, Grace wants to know, do you have a chart to share where they can share with clients on trust versus probate?
I could share the probate chart, which basically just says, here's the minimum costs of probate. The trust fees, so there is some trust administration. So if it's a spousal situation, when the first spouse dies, maybe there isn't that much trust administration and just a tiny bit. When the second spouse dies, there's definitely trust administration. If the trust is done really well and you've picked the right people and there's not a lot of drama and the assets are funded, then trust administration fees are not that high. But obviously if court is involved, then they go up. So, but I could share that chart.
Okay, we'll share that in the follow-up. And then Grace also wanted to know, can you email the advance directive to adult children?
So do you mean a form for them to fill out, or? I guess you can't ask questions back. So so there's several types of advance directives. One is the statutory one, which our legislature created. It is legally effective. You can look up California Statutory Advanced Healthcare Directive, and you'll find it. Make sure it's on the California government website, and you can find that. And so that's fine. You can fill that out. It doesn't have the bells and whistles, but it will work.
And for them to have a copy of the advance directive, just so they're aware of what the wishes are for the parent.
Are they if they're the next in line, I would say yes. If they're like 18 years old, I would say no. Sorry.
Yeah, no, that I think answers the question.
Okay.
Okay. Robert wants to know that you the chart that you showed about the probate and legal costs as an approximate percentage of the estate value. Is there a similar scale of legal costs when you are distributing the estate through a trust and not through a probate?
No, so most attorneys, I think, work hourly on that. So for example, we have a client now where we're helping with the trust administration. There's a little bit we have to do at the beginning and a little bit we have to do at the end. So I think his bill altogether will be $2,000 or less, plus our conversations and stuff, including our conversations. And so we're not doing that much, and we just tell them this is what you do. Some trust administrations have been $50,000 because it was a hoarder's house and the trustee was the wrong person to be doing this and couldn't handle anything, and we had to hire people to do everything. So you want to pick the right people, and you want to have your assets funded in the trust, and then it's a lot cheaper. But it's hard to say because I don't know. I mean, I do them where all the kids are equal beneficiaries, but there's a lot of issues between them and distrust. And so I'm talking and doing my therapy part of the trust administration, and so that jacks up the prices. So it really depends on the family.
Hourly on that behalf. Okay, and then Norma wants to know, have you ever worked with a challenging conservator who can't produce proper accounting ledgers?
It's awful.
Sounds like a nightmare.
Yeah, I mean, then we have to remove them as conservator because that's their job, for God's sakes.
And how long does that process take?
That's court. That's going back to court and saying this person, but we need a petitioner, right? So we just had another situation where a nephew was calling for his aunt. She didn't have any family in the United States. He was calling from Canada, and he was like the closest and only one. And she was so difficult that he said, I'm not going to help her. So she had been in the hospital since January. None of her bills were being paid. All these things were being forwarded to a neighbor. And she was at a community, and they needed to figure out what to do with her. But I don't have a petitioner. In order to go to court, somebody has to petition. So with that conservator, somebody has to be, or it's through the Office of Public Guardian or something. We need to figure out how to help them, but it can be tricky and expensive. So maybe better yet with that conservator is just hire someone who will kind of scare the shit out of them a little bit, right? And like we try that tactic.
If you have some people that we can share those numbers to scare the shit out of them, and we'll share. I actually have a question. On the escrow side, we see a lot of times, if a property's in a trust and they're selling it, for their proceeds, their bank account needs to be in their trust as well. And a lot of people don't realize that when you go to an estate planning attorney, they can drop the deeds to put the properties in the trust, but majority of time people don't realize that the bank accounts don't automatically go in the trust. Will you explain what people have to do in order to get those in the trust name?
Yeah, and so that's a really good question, because when I'm thinking of like how we practice, and we're super detailed, and I don't think I've ever talked about that with people, but when we're going through all the assets, we're saying, okay, this has to go in the trust, this can stay out, and this is what we do with it, or whatever, right? And so we talk about when they have large bank accounts that you have to convert that to a trust account. So you have to go to the bank. It's a pain in the butt. But you have to go to the bank and you have to say, I want to close this personal account and I want to open a trust account, right? So bank accounts have personal account, trust account, and business accounts. So you actually have to close that account. Now, if all of your automatic you know, debits and payments and things are going to that account, you can keep it open. You just have to move the bulk of the money into the trust account. But what I don't tell people is, you might not feel like you need to do that now, but you definitely are going to need to do it when you sell your house. But they don't usually reach out to us when they're going to sell their house, because everything's in the trust and it's just easy for them. But you're absolutely right. They have to do that.
Is there a reason why someone wouldn't want a bank account in a trust name?
Yeah, because sometimes people say, well, I keep like $10,000 at the most in that account. And so when we add up all their assets, it's less than the 166,000. So they don't have to.
Okay. So Grace wants to know what's considered a large bank account.
Millions of dollars. No, I'm kidding. Again, it depends, right? So you've got an expensive car that you don't lease, like you have a Tesla, right? And so it's like $80,000 or $100,000. Almost anything I'm going to say is now a big bank account, right? Because I got to count that car. So either we have to put the car in the trust or we have to deal with the accounts. But generally speaking, if you've got like $50,000, but I'm looking at all the assets, not just that account. But I mean, $50,000 is a lot of money to keep in a bank account. But it's relative.
Right. So personally, when I went and put my bank account in my trust, they let me at Wells Fargo just bring my trust cert and put my current account in the trust name. But I've been hearing they don't let you really do that anymore.
I haven't heard that, and every one of these financial institutions has their own rules, whether they're by the law or not. And so what I tell people is, when we're getting to the funding part of our process, is I want you to make an appointment with the bank manager. I mean, this is all pre-COVID, right? Make an appointment with the bank manager, and then I want you to say, what exactly do I need? So you're not just sitting around in this bank for 2 or 3 hours and then they say, oh, you don't have what you need. And so you just want to be as organized and efficient as possible. But yes.
Perfect. And then Norma wants to know, what is your hourly rate?
Our hourly rate is $4.50. And we do flat fees for our estate planning reviews that start at $8.95, depending upon what we're reviewing, where we review the estate plan and then meet with you for a couple hours to talk about it. So it's a good deal for clients. And then for flat fees for creating an estate plan, start at about $5,500 or $6,000, and then go up depending upon, because we are incorporating the transfer of business entities or the transfer of real estate in that flat fee. Or sometimes people will need special needs trust or other things as a part of it. And so it's just based on the amount of work we do, not based on how much money someone has.
Perfect. Marianne wants to know, if a car is financed, can it be put in the trust?
It can be, but we don't use, unless it's a really expensive car, we don't usually put cars in the trust.
Okay. And then Grace wants to know, is there any downside to having an account in the trust?
No, I mean, other than you're next in line to handle your affairs as your trustee. And you can have a different person be a power of attorney. So once the bank account is in the trust, your power of attorney has no access to that anymore. And it's just your successor trustee, which means we have to resign you as trustee. And sometimes older people are a little more open to having a power of attorney just help them, versus I'm resigning as trustee is a little bit of a bigger emotional hurdle.
Perfect. Okay, that looks like all the questions. Everybody looks like they put their email. If you haven't, we'll leave the chat open to put your emails in, and then we will send out a follow-up with these slides, the recording, and then the forms that Rebecca put as well, so you guys can have those to share with clients. Thank you so much, Rebecca. This was amazing information.
Thank you. And thank you, Lauren, for doing all that you did, and everybody at Glen Oaks.